My dear friends, students, after a long time, I'm conducting a specific lecture. I came to know that Mumbai University for the LLB second year, आप लोगों की 5 तारीख को एग्जाम है. ट्रांसफर ऑफ प्रॉपर्टी एक्ट, ट्रांसफर ऑफ प्रॉपर्टी एक्ट 1882 of Mumbai University on the 5th. Therefore, friend, there are certain students, certain professors have requested me. उन लोगों ने मुझे रिक्वेस्ट किया कि सर एक आप टॉपिक लीजिए तो थोड़ा सा स्टूडेंट को समझने के लिए कंफ्यूजिंग है. इट इज अ लिटिल बिट कंफ्यूजिंग टॉपिक. I would like to take the section 14. And this is section 40. You may be aware of this, friend. It is nothing but the rules of perpetuity. Therefore, this is a specific topic I am going to teach you, my dear friends. Now, under this topic, you are well aware about this, the Bare Act text. Let us read first Bare Act text, essence of section 14. No transfer of property can operate to create an interest which is to take effect after the lifetime of one or more persons living at the date of such transfer and the minority of some person who shall be in existence at the expiration of that period and to whom if he attains full age the interest created is to belong. After the Bare Act, my dear friend, there's something very important things that you have to understand each and every line. That is clause wise we will study that particular. But before that, you should aware one thing, my dear friends. You should understand a section 10 also. And therefore, after their section 30, these two sections are very much related with this because once a particular section 14 is applied for the particular case, that will be nothing but an injustice is going to take place for the unborn children. But what is section 10 is going to say, friend? Condition restraining alienations, where property is transferred subject to a condition or limitation absolutely restraining the transferee or any person claiming under him from parting with or disposing of his interest in the property. The condition or limitation is void except in the case of lease, where the condition is for the benefit of the lessor or those claiming under him. That is, property is transferred subject to a condition, what they said, or limitation absolutely. In short, I can say simply the section 10 says that any condition in a transfer of property which absolutely restrains, उसको रोका जाता है. The transferee from transferring by the way of selling, gifting, or otherwise dispose of the property. His interest in the property is a void. That means what it is there actually. I will give the illustration to you also, my dear friends. In short, I can say you can transfer property. A person can transfer a property, his own property, but you cannot completely stop the transferee from further transferring it to you. It means that someone is going to transfer the property to some other person, but the other person can also transfer the property to the other. That cannot be stopped as per the section 10, what we can say. Therefore, friends, certain illustrations are different that a person. Restraint must be absolute. Restraint must be absolute. Such absolute restraint is a void. In the sense, section 10 is saying if somebody is going to transfer the property to the other person, that is a transferee may be there. The transferee can transfer its property to the other, it cannot be restrained. Such absolute restraint is a void. If somebody is going to that particular property cannot be restrained by the person who is a transferor. Okay. Now, except there are certain exceptions. Lease for the benefit of lessor. Absolute restraint. Now, this absolute restraint, whatever case is there, suppose A is a person who gifted his property to Mr. B, correct? With the condition, but he put one condition is different. Condition. What condition is there, friend? उन्होंने एक कंडीशन डाला है. कंडीशन ये डाला है कि बी शाल नेवर सेल और ट्रांसफर दिस हाउस टू एनीवन। तो ये जो घर उन्होंने उसको गिफ्ट किया गया है, तो वो कह रहा है कि बी कैन नॉट ट्रांसफर अंडर दिस कंडीशन दिस हाउस टू अदर्स। दैट मीन्स व्हाट इज देयर, कंडीशन इज अवॉइड बी बिकम ओनर एंड कैन सेल द हाउस। इन द सेंस सेक्शन 10 ये बोल रहा है कि ये अगर किसी को गिफ्टेड घर किसी को गिफ्ट किया है बी को, और कंडीशन डाल रहा है कि वो मैं घर दे रहा हूं आपको, गिफ्ट कर रहा हूं, लेकिन आप वो किसी को सोल्ड नहीं कर सकते या बेच नहीं सकते। अंडर सच सर्कमस्टेंसेस सच टाइप ऑफ रिस्ट्रेनिंग इज नथिंग बट अ void as per the section 10. Therefore, friend, what exactly is the B is now full owner, absolute owner, what we are calling as is absolute owner, and he is having the right to sell his property or house to anyone. This is what a law is going to say. Section 10 is going to consider. This is one example what I have given to you. I चाहता हूँ that illustration is like this, friend. Second, partial restraint. Partial restraint. Partial restraint. Now this is the partial restraint. कुछ आधा part is going to put the conditions right now. Now what is that? A sells land to B with a condition. Now A is having his own land. He is selling to B with condition. कौन सा condition डाल रहा है वो? He is putting a condition. That is the condition. B shall not sell the land to C. Now he is saying that A is saying that I am going to sell you the land, but condition is that he should not sell the same land to C. It means that this is a partial condition. Now here the B is absolute owner of the land, but he is putting the condition he should not sell to C, but he can sell to anyone, any other person, any other person. Okay. Therefore, friend, this is the basic thing that what we can call a partial restraint, and this is nothing but what law is going to say. It is a valid agreement. This is a valid agreement. Therefore, friend, this is one of the second example what I explained to you. Now, friends, next point is there. Third illustration I would like. I'm trying to make you very much easy and to understand the topic. I already told you, friend, I'm not teaching any law, but I make you to understand the subject of law. तो इसके लिए तीसरा जो एग्जाम्पल है, थर्ड एग्जाम्पल, लिमिटेड टाइम रिस्ट्रेंट. लिमिटेड time restraint. This is another condition is different. Going to sell his land to be putting a condition that condition कौन सा condition है? He should not sell his land for before 5 years. Okay, before 5 years. Now this is the condition what he has put, but we can sell same land after 5 years because he is absolute owner of the land. Therefore, this is a particular condition agreement which is made. It is valid agreement. What we are calling it is as a nothing but a limited time restraint is there. Restriction is given. After 5 years, he can sell anybody, but before 5 years, he cannot sell to anyone. This is the third example what I given to you. Now, illustration number 4. You try to understand my point, what I'm explaining to you, my dear friends. Illustration number 4 is going to say that lease exceptions, lease exceptions. Now, what is the lease shop? He is given on a lease to Mr. B. The condition was there, he should not keep any sublet. He should not sublet the particular shop. This is what a exception is there. Therefore, this is one of the valid exception, my dear friends, and this is therefore it is a valid exception. Therefore, what I can say, this is particularly agreement which have been made by a person A to B. This is nothing but what we can say, a person can transfer his property under these particular things. It is nothing but B is not at all having the right because he is not absolute owner at all, but he is using the property of shop of Mr. A, and therefore this is the lease exception is there. Under such circumstances, when such condition is going to subletting is there, if we will sublet, immediately the contract becomes a void. If we will not sublet, the contract becomes a valid. This is another point. Now, illustration number 5, what I can say, my dear friend, restraint by restraint by direction of enjoyment. Now, what exactly? Restraint by direction of enjoyment. Who is enjoying the property? That is the most important. Now, what here is there? A gives property to B with a condition. A gives property to B. Condition. What condition is there, friend? The condition he says that B shall only use the property personally and shall not transfer it. Absolute restraint. This is he is saying that the property which is given to Mr. B, property which is given to Mr. B, that is nothing but property. Once it is given, it is what we are calling as the absolute ownership. Now this absolute ownership is there, but he is putting the condition that he should enjoy by himself. He should not transfer his property to the other person. Therefore, a person is nothing but is restraining for the enjoyment, for the transferring the property. Therefore, this particularly is a void agreement. This transfer is a void. Therefore, it is not going to be accepted as per the section 10. This is what I have given the illustration to you, my dear friend. This is very important. About the section 10, why I am telling section 10 is very important to understand. Unless and until you will not understand section 10 and 13, it will be difficult to understand a section 14 to you people, friend. Section 14, rule of perpetuity. Perpetuity will be asked your examination maybe for the long answer as well as the short answer. Therefore, what we studied about illustration and key, it is nothing but one is a absolute restraint. This is the first example what we are taken, right? Number one. Number two, what we studied, that partial restraint. We have already taken an example of this partial restraint also, my dear friend. Number three was their friend, what we studied, limited time restraint. Limited restraint. Number four is their friend, lease exceptions. Least exception. And number five was the friend, restraint by direction of direction of enjoyment. तो मैंने आप लोगों को ये सारे पांच एग्जाम्पल्स मैंने आपको दिए, इलिस्ट्रेशन आपको समझाया. If you will understand this particular topic, my dear friends, right, so this comes under section 10. What section 10 is going to say? Restraining somebody else for the alienation. Restraining, किसी को रुकाना, ये नहीं कर सकते, वो नहीं कर सकते, इसके हिसाब से बराबर है. Restraint. Therefore, this is restraining is a basic aspect is there. Now, what is alienation is different. Alienation is nothing but ownership. Alienation is nothing but ownership is different. This is a very important thing. That means the persons with the transferring property to the other or giving property to the other as the absolute owner करके दे रहा है और उसको कोई restrict कर रहा है, condition डाल रहा है. That conditions are not going to be accepted, my dear friend. Wherever it is valid, that agreement is a valid agreement. What we can say, the ownership can be transferred validly, with validity. If some restrictions have been put right, that is against to the section 10. Under such circumstances, it becomes a void agreement. What we can say, the ownership will not be transferable. It is a void itself. This is the basic thing what I tried to explain to you. Section 13 is going to say, my dear friend. Once you understood, my dear friend, this is a very important thing. This is basically what we are talking about, restraining the property, etc. Now the question is arising about an unborn person is there, my dear friends. That we will come to the point. Now section 13 is there. What section 13 is going to be say? Section 13, shortly what I can say, my dear friend, transfer for benefit of an unborn person. transfer for benefit of unborn person. Transfer of benefits to unborn person. मतलब ये है कि ये जो अभी तक दुनिया में आया नहीं है, he has not came into the world. That means he is in the mother's womb. Therefore, this is a basic thing. Now, apart from this, friend, what we are saying, section 13, what it is basically saying that it allows property to be transferred for the benefit of an unborn person, but only if the entire remaining interest of the transferor is given to that unborn person. In short, an unborn person can receive property but not a limited interest. Now, here is a word they have mentioned: absolute and limited. Now, what exactly the meaning of this, friend? Now, this unborn person may be the womb or may not be the womb. In future, he may come, right? But he is having the right in the property which is going to be transferred. Therefore, someone is going to transfer his property to someone. Therefore, the property which is going to be transferred to the unborn person as per the section 13, it should be a fully, it must be a full interest must be there. There should not be any part interest. Therefore, we can say the property which is going to be received, it should not be limited interest. So whatever the absolute ownership is there, absolutely it must be going to transfer to the unborn person. This is the basic thing, my dear friend. I would like to explain to you, but for section 13, you will understand my topic, my dear friend. I would like to explain you with a very simple manner, my dear friend. You try to understand the illustration. By illustration, friends, you can understand the topic basically. Now, what exactly is A transfer is property to B for his life? For life. Okay. After the death of Mr. B, the property which is a prior interest with prior interest will be transferred to the unborn child. This is nothing but a valid reason is different, valid transfer is there. Now we are talking about the transfer of property, right? Transfer. How the transfer takes place, friend. Okay. Now this is one of the example. Transfer his property B for a life, but after his death, with the prior interest of this will be transferred to the unborn child. This is number one. Number two, A transfer his property to B, okay, for life, and after B's death, the same will be transferring to the unborn son, that is a C, unborn son. This will be transfer only take place, that is a life only for the life interest. Only for life interest. Under such circumstances, my dear friends, this particular transfer will be invalid. Invalid. This transfer will be invalid. Therefore, the transfer will be going to be void, my dear friend. This is very clear cut. Transfer is void as to unborn person, because this is nothing but what in first case it is a prior interest is there. Here there is no prior interest, my dear friend. Under such circumstances, if the transfer has been took place, right to friend, the person who is going to be the particular transfer will be void. Number three is different. This is a very important thing, prior interest, my dear friend. Prior interest. Now, this is a prior interest. We also utilize the word here prior interest, but here is no prior interest, my dear friend. Under such circumstances, A transfer its property to B directly to the B, right? To transfer to directly to B and to B's unborn son. To B's unborn son. Unborn son. Now, here the word what we are utilizing, the B is also a alive person at here, friend. B is a alive person. In first case, the B was a died. In second case, B was a died. Here B is alive. A directly transfer the property B, and B directly going to transfer to the unborn person. later on also. That is going to validate things, my dear friend. Now next point is different. Next illustration I would like to take, my dear friends. I hope that you may be understanding. आपको समझ में आता रहेगा शायद मैं जो कुछ भी आपको बता रहा हूँ. Therefore कुछ conditions है, you try to understand, my dear friends, very simply. Now fourth example, whole remaining interest not given invalid. A transfer property to B for life and after B's death to B's unborn son, but with restriction that he cannot sell the property. Unborn person does not get absolute interest. The transfer is invalid. Therefore, what we are saying, whole remaining interest, whole remaining interest not given. In the sense, what I can say right to my friend, A has transferred his property to B. This is the very clear for a life. Okay, for a life. After B's death, after his death, right, my dear friend, unborn child or person, maybe C, maybe C, he is restricted for this that after the getting the particular property to the concerned person, that is the C, for the life of C, but he cannot sell that property to anybody else. He cannot sell the same property to anyone. In the sense, what I can say, my dear friend, he is not having the absolute ownership, or we can say a life interested ownership, my dear friend. Under such circumstances, if some conditions have been put, this is nothing but a void transfer. This is nothing but a void transfer. Therefore, this particular transfer becomes invalid. And the last example, what I can give it take to you, illustration is different. आखिरी जो इलिस्ट्रेशन है सेक्शन 13 में का, आप समझने का प्रयास करिए. ओके, व्हाट इज दैट एक्चुअली? एब्सोल्यूट इंटरेस्ट गिवन, उसको एब्सोल्यूट इंटरेस्ट दिया गया है. Given. What is absolute interest? I said the ownership, which is nothing but absolutely given, it is there. Therefore, the person, for example, A transfer his property to B for life, and then B's unborn daughter absolutely. Okay. उसके बाद में उसकी unborn daughter जो है, daughter, उसको दिया जाता है. तो this is what unborn daughter, she is given the absolutely ownership is given, my dear friend. Ownership, what we can say. Now, what is absolute ownership? That means she can further in future, she can dispose of the property, or she may be sell the property. That is the basic thing. That is basically what we are talking about here, friends. These are the 5 illustrations what I have given to you, my dear friends. Now, there are further. This is section 14, rules of perpetuity. The detail for by clause I would like to explain. No transfer of property can operate. This means any mode of transfer like a sale, gift, will, or settlement, trust, etc. If the transfer violates these rules, that part of the transfer becomes void. To create an interest which is to take effect after the selection, this section deals with future interests, present or vested interests are not affected. If ownership or interest is postponed to a future uncertain date, means ownership cannot be postponed indefinitely. Section 14 applies. It will be explained. Now, I will read a bare act. What exactly is there? Section 14. What is section 14 is there, friends? Okay. Now, this section 14, what it is going to be say right now? No transfer of property can operate. No transfer of property can operate. इसका मतलब क्या होता है? Property is going to be transferred, my dear friend, by the way of sale, gift, will, settlement, trust, etc. Okay. If the transfer violates this rule, that part of the transfer becomes a void. अगर इसमें जो 14 सेक्शन में जो हमारे बेर एक्ट के हिसाब से जो रूल्स दिया गया अगर उसको वायलेट किया जाता है, हाउ इट इज देयर आई विल एक्सप्लेन टू यू फ्रेंड. Under such circumstances, the particularly transfer becomes a void transfer. The lifetime of one or more persons living at the date of such transfer. These are called lives in being. The law allows postponement only during the lifetime of persons alive at the time of transfer. You cannot use future unborn generation as a measuring lives. Example, A, B, and C are alive. Their lifetime can be used. 14 is applicable, my dear friend. Section 14 is applicable because maximal permissible period is there, my dear friends. लाइफ बीइंग जो जिंदा है उसके बाद में जो पर्सन जिसको ट्रांसफर ऑफ प्रॉपर्टी करनी है उसका एज है वो मेजॉरिटी एज के अंदर यानी कि 18 साल के आसपास चाहिए. अगर 21 साल है इफ द गार्डियन इज देयर माय डियर फ्रेंड, इफ एनी गार्डियन इज अपॉइंटेड 21 साल चलता है. अंडर सच सर्कमस्टेंसेस इफ इट इज गोइंग टू ट्रांसफर आफ्टर दैट ultimately this transfer becomes a void. It's a very clear. And the minority of some person who shall be in existence at the expiration of that period. After the death of the last living person, only one extra period is allowed. The extra period is a minority, 18 years normally, 21 years if a legal guardian is appointed. Any period beyond minority is prohibited strictly. Clear. Why this particular section is made so strict? The reason is only that ensure free circulation of property. प्रॉपर्टी का मोशन होना चाहिए. न तो किसी एक के पास प्रॉपर्टी है, ए के पास बी को गया, बी के पास सी को गया, बाद में डी को गया, बाद में ई को गया, like that, my dear friend. But here some conditions have been put. While transferring the particular property under section 14, they said that if someone is going to transfer the property, the person's age should be 18 in case that is the majority is what we calling a major person, or 21 when any guardian is appointed. Guardian is appointed. अगर इसके ऊपर किसी की उम्र जाती है, इसके ऊपर अगर कोई जाता है और ट्रांसफर करने का प्रयास करेगा, that cannot be transferred. Why it is like that? Because some indefinite period cannot be given. Therefore, specific period must be there for speak. Therefore, the property which is going to pass by A to B, C, D, E, etc., etc. But this particular condition must be applicable, must be followed by different. इसको follow करना जरूरी है. Otherwise, what will happen? The property will be tied up. It will be stuck up. That property cannot go anywhere. It will remain as it is only. That cannot be utilized. Therefore, this particular section made in such manner that particular property should be transferred from one person to the other person. Therefore, this has been made. Therefore, free circulation of property should be there. It should not be tied. Prevent family domination over property forever. किसी फैमिली का डोमिनेशन रहता है, मेरी प्रॉपर्टी उसके बाद मेरे पोते के मेरे लड़के की प्रॉपर्टी उसके बाद मेरे पोते की मेरे लाइक दैट इट इज गोइंग टू बी continuity with them only. This is nothing but it's going to be prevent family domination of over property. To protect economic and social mobility. Protect economic and social mobility of the public property. Public. It can be utilized for the public also. You know, friend, if any land is maximum permissible period formula, life in being plus minority 18 or 21 years. Anything beyond this equal to void transfer. By section 14 is a strict ensure free circulation of property, prevent family dominations over property forever, protect economic and social mobility. Social mobility. There, nobody is going to claim on that land. That land is going to become a government, state government, or central government land is different. This is a basic idea what I told you. Now, friend, Tagore versus Tagore, one case is different. Tagore versus Tagore, a case is there, friend, that I would like to explain to you, friend, that what is the case comes under 14th section. Mr. Tagore was a Jamindar. Jamindar, okay. Rajendra Naim, Raja Rajendra Tagore versus Tagore, Bengal. He was a Jamindar, very wealthy person in the Bengal. he was under Hindu, he made a will in favor of unborn child. Unborn child. Okay, he executed a will in the favor of unborn. In future generation, which is not in existence, not existence, automatically as per the will, a property will be transferred on their name. That is a person who is not in generation, not existing, even though not in the womb of the mother. Accordingly, he made a will. After his death, right, my dear friend, there was some crisis took place among the family members. Among the family members. Now, what law says that section 14 saying that any transfer of property of the unborn person, it should not be transferred on his name, subject to if the unborn person who is a womb into the mother, even though it is not a property, is not going to be applicable. For example, I told you A transfer a property B actually going to transfer a property unborn person. That is what we are saying. C. Okay, C is not in existence. Now, what law is going to be say right now, my dear friend? Under such circumstances, if the person who is unborn, the property cannot be transferred on his name unless and until he is in exist. After exist also, what law is going to be say? Before 18 years or 21 years, if the guardian is appointed. Before that, the particular property must be transferred on his name. That is the basic aspect is concerned. But what happened in this case right now is Raja Rajendra Tagore, he made a will as per the Hindu law, my dear friend. He already mentioned, executed a bill that whatever the future generations will be there, which may not be existing now, automatically the property will be transferred on their name. Therefore, under such circumstances, what we will find, my dear friend, such transfer will be invalid as per the section 14. Therefore, friend, this is a very important. Now the question is arising to the persons after in future who is going to be born. What will be his right? His right will be protected under section 10 and 13. Is a friend. Correct. The name of the case is Ram Nevaz. Ram Nevaz versus Nanku. This is the case of 1921. The previous was a 19. Previous case was 1872. Okay. Now, what exactly we are going to say? Now, this person is a transferor, or you can say maybe owner. Okay, transfer or settler. What we can say, settler. To understand such now Nanko is a claimant of the case. He is a claimant. Case took place into the court and he becomes a claimant. Now this property belonging to Mr. Ram Nevaz, it is the same case is there. Now Ram Nevaz is a owner of this particular property. Now he transferred his property on the name of Mr. B. His successor is there. Okay. Thereafter, this property, he directly transferred to the unborn person. He made a will who is not in existing. Nevaz, he transferred his property to B, and after this B, right now, the same property is supposed to be transferred on the unborn person who is not in existing. Under such circumstances, right now, the Nanko is a person, right now, my dear friend. Therefore, he cannot be claimed for his right under section 14 because he was not born also. Therefore, what we have understood, my dear friends, the person who must be in existing, to whom it is going to be transferred must be in existing. If unborn person is there, unborn person, unless and until he will not come into the world right now, my dear friend, the property cannot be transferred. Even after this, if he is born, under such circumstances, 18 and 21 years is a very important aspect. Therefore, then only before that only the section 14 is allowing to transfer the property and that property becomes a absolute property or in the lifetime property. Okay. Under such circumstances, if the property is going to transfer after this particular major age, that transfer becomes a void transfer. This is a very important, friend. Therefore, I hope that you might have understood it. And finally, friends, I tried to explain you the all these particular lectures, and now I will try, friends. Please like, share, and subscribe this channel because I have planned to deliver my lectures free of charges to the law students because I am having the ample of exam uh, experience about it. I was a paper chairman of the paper setting for the LAB third year also. I set a paper also. I tried to make it very easy to the students. My book is also available for the business law in the market. But so far, my point is concerned, my dear friend. For the examination point, you try to cover the entire things, try to write it, my dear friends. And I hope that you might have understood my topic very well. I giving the best wishes to you. आपको मैं शुभकामनाएं देता हूं। मुझे पूरी तरह आशा है कि मैंने आपको समझाने का प्रयास किया है। आप मेरी पीपीटी को एक नजर से देख लीजिए, आपके समझ में आ जाएगा। आई एम गोइंग टू गिव द इलस्ट्रेशन टू आल्सो ऑन दैट पीपीटी माय डियर फ्रेंड।